if I tell you that I have a vision in which I'm going to make it affordable to every legal practitioner out there, struggling to build a practice and to survive, to have a chance to do it within his or her budget? What if I were to tell you that I have a vision of making it possible for so many people who cannot afford legal assistance to get access to courts, to bring them within reach of a legal practitioner who can help them? What if I tell you I have a way to break down the barriers to entry into the legal profession? What if I were to tell you I can envision a way forward where there will be affordable resources available to all aspiring new legal practitioners? And what if I were to tell you that I can and will achieve this? This is the post that I have pinned to the new Lex Vivens group I have started on LinkedIn, and that went live last night. Please hop over to our LinkedIn group and join the group if you haven't done so. My name is Christy Hutton, and welcome to our new podcast, Lex Vivens. Today we are featuring our first episode ever, and we're interviewing my spouse, Karen Hutton. And full disclosure, this exercise did not come easy. It was profoundly difficult for us to actually do it. To appear in front of a camera is totally different from appearing in a courtroom. So for us, this is completely new. For me, it is completely new. But unfortunately, we have to get through it, and we have to just soldier on, because this is the only way that we're going to be able to reach you and bring this message to you. I do have a way. It is going to take time, and I'm not going to reveal everything at once. There's a process involved, unfortunately, and it's going to involve you. It's going to involve you because we need you to interact with us, to participate, and to let us know what the pain points are, what the issues are that you are struggling with. That would require you to please hit that subscribe button, smash that like button if you like where we're going with this and you want to be part of this process. And furthermore, in full disclosure, we are not monetized. The site is not monetized. And there will be probably and hopefully an income stream long down the end of the road, but that's not what we're aiming for. We are really aiming at this stage of our careers to try and help, to reach out and help people. That is our drive, that is our motivation. Now, onto a lighter note, you will see from the commencement of the interview that I have recorded, is that there's a blooper in the beginning, and it's really, it was a painful exercise to actually record it, because it's so new and because we're so uncomfortable and so on. So I've made a complete hash of the lighting, of the recording angles, and everything is wrong. So I actually thought of not putting it out there, of not showing it to you. But then I thought that would be against the principles that we are teaching, and the philosophy that we are going by, that failure is okay. It's all right to make mistakes. Own it, and be honest about it. And you'll see through this journey, as we go along, how we're going to build you up and build you. And we can't be truthful in those teachings and those philosophies if we don't practice them ourselves. So if you're going to make yourself vulnerable by telling us what your pain points are, what your issues are, and what your expectations are, what your dreams are in terms of this profession and how we can help, we thought that putting our first hopeless video out there would probably be, uh, you know, entertainment enough, so that you can at least see who we really are, and it is also just fallible people. We all are. Thank you for watching. Thank you for your participation. We really appreciate that. And without you, this channel was not going to be possible. So we really urge you to please participate And that way we will keep motivated to keep on putting out the content there that will help you. Thank you.
Good night. We have.
Good night is this part.
And good evening. Tonight we have our first guest here in our podcast, Lex Vivens, on our first ever attempt to do a podcast. I want to introduce to you my dearest wife, Karen Hatting, who is a seasoned conveyancer and a legal practitioner in KwaZulu-Natal with her own firm, Wessels and Hatting Incorporated. Now, as a senior legal practitioner, Karen, tell us a bit. You're an admitted attorney with right of appearance in the High Court of South Africa, a conveyancer, a dynamic woman who runs a successful practice, managing staff, being a devoted wife, and a loving mother. How do you do it all?
I hope to say it's successful, but I try to keep all the balls in the air. I think how I do it all, I've got a support system, a great one, and just try and manage all the things, do them to the best of my ability.
And how long have you been in practice now?
Well, I was actually looking through photos the other day and I came across the photo of my admission as an attorney and conveyancer. It was in September 2007. So it's 24 years now. Can't believe. No. 17 years. 17 years. However, I've been working since year 2000. That's been 24 years.
Time flies. Tell us now, in your years of practice, what is the funniest incident or anecdote that you can share with our listeners?
I tend to fall easily. So there have been various incidents where I've either fell downstairs at the deeds office, fell over my own feet at the High Court, or also fell in the streets in front of the deeds office in the High Court. So I was thinking of those, but I do recall one incident specifically when I was representing a maintenance client in maintenance court in Camperdown, and they just refurbished the whole court, and they put these very fancy systems in place where the court, you could only gain access to different areas of the court by putting your thumbprint. They'd activated, but they hadn't actually implemented it. And I needed to take instructions from the specific client about an offer that was made. And at this stage, I was quite irritated with the client. She was a difficult client. And then we went through to have some privacy in a little hallway. And the door closed, and both of us were locked in. And I couldn't get out. And the door was next to the regional court, and I was banging on the door. We were there for about an hour before somebody eventually came and found us and opened up the door.
Now tell us, what would you attribute your success in your career to? And please don't tell our audiences because of the wonderful husband that you were married to.
You are a big part of the success. As I said earlier, support systems, and yes, if it wasn't for my support systems like you, our children, staff, and number one staff member and confidant is my mom, who at age 77 is still working.
She means a lot to you.
She means a lot to me, and the office, and she's really a rock on which I lean heavily on her support.
Just tell us a bit about your background. Where did you start in the legal profession?
So my parents, my dad was an attorney, and he and my mom started the practice which I currently run in
It's
19...
now called Vessels and Nothing.
Yes. At that stage, it was Pete Vessels, my dad's name. They started that in 1977, so it's been quite a long time. And my mom is worked in the collections department and has been running the collections department and still is. So I grew up in a legal, what could say legal household.
Household.
Yeah.
Oh.
But my initial thought with regards to studies I didn't have a definite idea to go into the law. I decided to do a BCom law, so that I could have the choice whether to maybe go in the accounting direction. I did accounting at school and liked it quite a bit, but things sort of fell in place after events in my life, and yes, and then from a BCom law, I did an LLB, both through UNISA and whilst I was working. So it took me a little bit longer than...
So you didn't go off to varsity after school?
No, I didn't.
So
Yeah,
you started as what?
I started working as a legal secretary.
The year after matric?
It wasn't directly the year after matric, so I had studied the first year with BCom,
okay. And
it was the second year when I started working, and I did not know I knew nothing about computers, but somehow I started dictate typing, and yes, worked up whilst I was studying, and managed to get a degree and continued, then did my LLB and did my articles.
So you said that the events in your life after things happened and it just fell into place. What do you want to share with our audience? What are the events that you're referring to?
So I was 18, but I finished school at 17. It was my...
Just quickly, how did that happen?
Well, I just passed matric. I was in a very small school at Cato Ridge. It's now called George Cato, a lovely school where all my siblings were, and we were combined classes. So the Afrikaans class, standard 4 and 5, now grades 6 and 7, we were all in one class, and unbeknown to me, the education department tested me, and I was progressed from standard 4 to standard 5 in 1 year.
Oh, so you skipped a year?
I skipped half of standard 4 and half of standard 5. So
okay.
Yes.
So you wrote matric when you were 17. You left school.
I turned 16 in October.
Good.
And wrote matric and finished off school. So I literally couldn't get a driver's license because I was not legal yet. So my first year I did a BCom through UNISA, but at Varsity College I did go head class, and my dad drove me in every day and out, fetched me from Camperdown to Pietermaritzburg.
Okay.
But then second year, yes, it was in April 99, my father passed away, and it was, I still recall, a public holiday, Freedom Day, and
he had cancer, is that right?
He had cancer of the lung. I don't know,
but eventually
he passed away from a heart attack, and at home. But so it was sudden. He didn't die of the cancer itself, and I tried to resuscitate him because he collapsed at home, and that was quite a.
At the age of 17.
I was 18 at that stage, yeah. But, so it was quite traumatic.
Not for a girl of 18.
I don't think for anybody. It's but yes. So he died the April, and it was not 3 weeks later. My eldest brother Dion, who was at that stage doing his articles at the office, he studied law, was tragically killed in a car accident. So why I say it shaped my direction, is at that stage I hadn't for definite decided that I was going to do law, but my mom.
And Dion was supposed to take over.
He was supposed to take over the practice. I'm one of 4 siblings. I've got 3 siblings, one of 4 children. The other 2 brothers did not go into law. So Dion was going to take over, and then I was studying still. And my mom had to make very difficult and big decisions at that stage with regards to the practice. Long story. I focused on law and got my degrees, and eventually took over the practice. And yeah, it's now been 15 years since I've been practicing on my own.
Oh, well done. So it was full circle. You took over the practice.
Full circle, yes.
Oh, fantastic. Now tell me, you are more focused on conveyancing in your practice, am I right?
I've got a general practice. So I do litigation, quite a bit of litigation, correspondent work, estates, and conveyancing. I'm an admitted conveyancer, so I go to the deeds office every day, and then, well, I manage my days as I, if I've got trials or court appearances. But yes, I attend the deeds office daily. With regards to conveyancing transactions, we lodge our own deeds.
Now, as a general practitioner, in your years of experience, what would you say to our audience? What is the most valuable lesson that you've learned as a legal practitioner? Forging your own way as a young lady, young woman in the profession against adversity.
Yes, I think it's not an easy profession. You're not going to.
Why do you say that?
It's not an easy profession, in the sense it's very stressful. You've got a lot of pressure to perform as you looking after your clients' interests. There's different.
Would you say it's more so for a general practitioner, or is it in all aspects of the profession? Is it stressful?
I would say in all aspects. It is. There's a lot of regulatory stuff that we need to comply with. In any of the aspects, whether it's conveyancing, estates, courts, you dependent on a lot of other factors or other participants in the process in order to be able to do your job properly. For example, if we're in the conveyancing process, one of the participants in the process is a municipality who needs to give a race clearance certificate. So if there's a problem with the municipality, then it affects the process of the conveyancing.
It delays the transfer.
It could delay the transfer if there's a yes.
Okay.
Same with if it's with regards to estates. We have to deal with the master's office, who issue the letters of executorship and who have to,
But the sort of stress that you talk about, I mean, it's the good type of stress in the sense that it keeps you on your toes and it keeps you busy and focused all day, and not one day is the same, is it? Is it?
Yeah, as a general practitioner, I don't have the same day
There's
no repetitiveness. So each day does bring its own challenges. It brings its own new experiences. So yes, no, I do enjoy being a general practitioner. I can't talk for people who specialize in one specific area, how they experience it. But when I'm talking about stressful, it's a stressful profession. So when with regards to young people going in, it's nothing like you see on TV, and especially not American TV. So it's the big glamour and walking into court and just telling everybody what should be done. It's not that. There's
No, you don't just walk into court and tell everybody how it's going to be.
No. And to understand the processes and to experience different fields of law, I must say I do enjoy that.
But you do get a lot of support as well in the legal fraternity from colleagues and
Yes,
that sort of thing.
yes.
Especially in the conveyancing fraternity, because it's less adversarial.
It's less adversarial. We're not fighting against each other the whole time. So you walk into the deeds office, for example, where we'd see most of the conveyancers who are lodging agents or lodge their own deeds. It's quite pleasant. People are chatting how you're doing, and it's not, you've got your deadlines, etc., but it's not so stressful. You do have your stresses with regards to the process, yes, and whether to get the transactions registered, and you get your problems with that.
I don't want to go too down the whole process because we're going to in the next video, and I don't want to I don't want to give away too much at this stage. But I know we are planning in the future that you're going to take our audience with the camera into the deeds office and show them how things are done, and we're looking forward to that. But let me just get back to a few questions, maybe perhaps focused at our broader audience, the broader public, general public out there. Property deals often go wrong, don't they? And it becomes litigious. People start fighting.
I think the percentage wise, most of them would go through smoothly, but you've got your good measure of ones that do become litigious. That's why there are clauses in the agreements that make provision for when they do become litigious.
So can we just unpack this for a while? So there's a purchaser, there's a buyer and a deed of sale for a property.
Seller and a purchaser.
Seller and a purchaser, and then you've got the estate agent that's involved, and you've got the conveyancer that's involved. So there's actually 4 parties really involved, and then that is just before you even start getting to the deeds office.
Yes.
So when an estate agent introduces a seller and a buyer to each other, and they get to actually present a written offer to purchase of a property to agreement. What is the estate agent's part in all of that, and what are their responsibilities towards the public?
Well, estate agents play a big role in the conveyancing process. So they have a seller who normally gives them a mandate. Written mandate. They always give them a mandate to sell, but it should be in writing. To say, here, market my property, and this is my purchase price I'm looking for. Then the estate agent would market the property and introduce potential purchasers to the property, view it, go and have a look. And if there's a purchaser who is interested and wants to make a purchase, they would then complete normally, and estate agents have a pre-printed, determined contract or offer to purchase, which they complete, but it does require the correct information to be completed.
And can we just emphasize this fact that a deed of sale, does it have to be in writing?
Yes, it does. If it
And
with
why?
regards to immovable
Or
property.
And why
So,
is that?
Okay, so just to explain, immovable property is a house, it's a farm, it's property that is registered or registerable in the deeds office. And in terms of the Alienation of Land Act, it is a requirement that any sale or transfer of a property is recorded in writing. So if you're purchasing a property, it has to be in writing. You've got to sign it, both the seller and the purchaser. Another written document that can lead to conveyancing is if you've got a will and you pass away and I bequeath my property to someone, that would be the written instrument on which it's based.
So there's got to be some form of written instrument
Yes.
regulating. And what are the requirements for a legal written instrument or to be a legal document, legal binding document?
So the seller and purchaser must be identified on the agreement. The property, so it doesn't have to be the exact cadastral description, but it must be identifiable. The purchase price, and the parties must sign it.
Now, getting back to the estate agent's involvement, there's in the mandate agreement with the estate agent, they normally conclude an agreement with their client for estate agent's commission.
Yeah.
When does that become due, owing, and payable? At what point in time, as a member of the public, as a seller or so on, when do they become liable for that estate agent's commission?
So the seller would appoint the estate agent, so the seller would be liable to pay the agent's commission. The agent's commission becomes due or enforceable by the agent once the agreement has been signed by both parties, meaning the seller and the purchaser, and all the requirements of the agreement have been fulfilled. For example, if it is a cash purchase, which means the purchase price is payable, the full purchase price payable in cash, EFT, then on date of signature, that would be a complete agreement and the estate agent would be entitled to his or her commission. However, if the agreement is subject to a suspensive condition, like the purchaser having to obtain a bond, the agreement becomes enforceable once the bond approval has been given, and then the commission.
And that's only because that condition has been met.
Because the condition has been met.
And that triggers
it triggers the
enforceability
claim of the agent. Yes.
Okay. Now, I've often heard people ask the question, and again, I'm going to the broader public out there. When they are presented with a offer to purchase, who appoints the conveyancer, and who's got the right to appoint the conveyancer?
It's often asked question. So in South African practice, it's the seller who has the right to appoint the estate agent. Long ago, it was for some, well, there were reasons, but there was a decided case where only in KwaZulu-Natal it was the other way around, where the purchaser was. But that has sort of fallen away, and everybody's on the same page. So mostly the seller would appoint the conveyancer.
But is there any law or any substantive provision that dictates, was it by agreement, or how does it work?
Well, the offer to purchase is an agreement signed by or entered into between the seller and purchaser. So it's not a it would, in most instances, the agreement would say, already have a clause in saying the seller nominates the following conveyancer, and then that would be open for the seller to complete choice of the conveyancer. But sometimes seller doesn't have a conveyancer, or isn't worried whoever gets appointed, and the purchaser.
But is it important who the conveyancer is? Does
It
it matter?
Yes, it does matter. The seller is the person giving the transfer, or is required to convey the property, to ensure that transfer is given. So the seller appoints in order to make sure that that process is done. However, once a conveyancer is appointed, they've got to look at both parties' interests. So it is important to appoint a conveyancer who knows what they're doing, and because number one, it involves a lot of money, and it's not in many instances people only do it once or twice in their lives to a property transaction. So
you're talking about members of the public.
Members of the public, yes. Yeah, not as an investment.
It's not like you go out and buy bread every day.
Yes,
you buy property or a house once or twice in your life.
Yes. Yeah. So because it involves a lot of money. So the purchaser, if the purchaser says, well, I would like this conveyancer to be appointed because I have a good relationship with the conveyancer, and the seller has no objection, they can put the purchaser's conveyancer in and agree to that. It's a question of whom agrees, but in most instances it's the seller's conveyancer who is nominated.
Now, what are the conveyancer's duties towards the seller and the purchaser respectively in a transaction?
So for the seller, the conveyancer has to ensure that the purchase price has been secured, whether it's by way of the deposit into the conveyancer's trust account, or by way of a guarantee obtained from a bond that is being paid, or it could be that the purchaser is selling a pre-owned property and that the funds would be coming from that, however way it is. So the seller, apart from the legal documents that have been drafted that need to be submitted and lodged in the deeds office, has to ensure that those conditions have been met. From the purchaser's point of view, the conveyancer has to ensure that the terms have been also
obviously
complied
money
with.
is there.
The big thing is purchaser's money is normally paid into the conveyancer's trust account to invest that money if there's investment mandate, to ensure that that money is safe, is not paid over to the seller until such time as the transfer has been registered in the deeds office.
And it's then when that reciprocal obligations actually take place, or
once on the day of registration, when it passes the transfer ownership passes to the purchaser, then the purchaser's money is paid to the seller.
Okay. Now let's just talk about the trust, attorney's trust account, and so on. You so often hear of attorneys that have taken money out of their trust account and so on. Can you just tell our audience out there what is the purpose of a trust account, and is their money really safe when it's in your trust account?
Yes, it's unfortunate that legal practitioners do take money from a trust account, and it gives the broader legal profession a bad name when that happens. So as legal practitioners, we run two accounts. We've got our business account and a trust account. Trust account is there to keep clients' money. So it is supposed to be safe. We are covered with by the legal practice insurance
Fidelity
Fund. I think
Yes.
LPIA, and legal. You also can take out legal insurance for it, but that money is your client's money, and it's not to be used for anything else.
What happens to attorneys if they take money out of the trust account that they're not entitled to take?
Well, if there's a shortfall on an attorney's trust account, they will be reported to the Legal Practice Council, and in most instances they are suspended pending an investigation. The whole process is, I'm not sure.
And it leads to disbarment.
It could lead to them being
Disbarment
struck off the roll,
and even
and criminal
criminal proceedings,
proceedings.
as we've seen. Now tell me, a thing that I've been wondering about is in your career, have you had any, mishaps where you've disappointed clients or made mistakes,
Oh,
made
yeah.
errors, failures?
Yes, hopefully not too many, but as a human being, you will make a mistake.
How do you deal with it? And how do you fix it?
How you deal with it, obviously it's not nice to make a mistake, or to, whether it's a mistake or whether it's a question of losing a case, it's disappointing because you get emotionally attached to the matter or to your client.
Is that a good idea, to get emotionally attached?
You shouldn't, but inevitably it does affect you.
It does rub off on you.
It does rub off on you. One thing I have learned is in this profession is to grow a thick skin. You mustn't take things personally. But yes, I've had failures. I've made mistakes. Big thing is to own it and to admit when you're wrong.
Apologize and move on.
Apologize and move on, otherwise you're not going to grow.
Exactly. Yeah. And my philosophy, being married to me, is that one grows from your failures. What's your feeling about it?
Yes, one does. You learn what not to do. You learn, definitely, if you had this specific scenario in a matter and you come across certain type of scenario in future, how to deal with it then, and also by that passing it on to other people, giving some advice when you see they might be going down the same road as you did, or making a mistake, even in small things, how to address a magistrate, and you see that somebody might be doing it wrong, as you say.
I often wonder, whether it is, the people that own up to the mistakes that they make, admit it, and own it, often get branded with that, they get labeled for making mistakes. But everybody makes mistakes, and other people who don't own it just try and bury their mistakes, and it becomes a bigger problem later on in life. Don't you think so?
Yes, well, I do think so. I think, it might be branded. In I think in life people don't want to admit if they've done something wrong, and you don't want to look weaker.
But I think people have a lot of respect for somebody who can own their mistakes and can correct them and move on.
I think so. I think it's
part of building character.
It's part of building character, and I don't think one should
Let me
No
use this
judge.
example. Let me
Yeah.
use this example. You've got an employee, or you've got 2 employees.
Yes.
Okay, well, the one makes a mistake, owns up to it, admits it, asks your forgiveness, and say, "I'm really sorry. I know what I've done wrong, and I'll improve and do better." Other one also makes a mistake, but you don't find out about it because they bury it, and they always pretend to be, goody two shoes and doing everything right, and they go and leave. And once they're on leave, you take over their files and you uncover all these dirty secrets lying underneath the shadows that they've been hiding from you. Which one is the one you're going to reprimand or give the call before a disciplinary hearing?
Yes, no, definitely. I would trust the person more, the one who owns up.
No. Tell me now, if you had to give some advice to the younger, if you could go back in time, for example, and you could give some advice to the younger you, the younger Karen, what would that be? What would that message be?
I think to tell me that it's important to make time to look after yourself physically and mentally. Is to check in with yourself often. It can be such a mad rush, keeping all the balls in the air. Running matters, doing this, doing that, making sure you write fees so you can pay overheads, so you can pay salaries. Then you tend to forget about you. Mental health is also a big thing. And I think there are lots of practitioners who struggle with it, but it's also not something we show because we're scared again to be branded that you're going to be seen as a failure.
It's a sign of weakness.
It's a sign of weakness, yes. Whereas it's important to look after yourself.
Interestingly enough, today on one of my LinkedIn feeds, I saw a post by an American lawyer who said that there's often so much adversity amongst lawyers in the profession, probably born out of jealousy, perhaps sometimes born out of trying to hide my weakness. I don't want you to see my weakness. I'm going to try and show that I'm strong, and and I look strong when I'm aggressive and angry. What is your attitude towards that, and what is your feelings about that?
I've got a view that be kind to your colleagues, and many are. Even if we are opponents in a legal matter at court, and our clients dislike each other or really feel that you should be doing the X, Y, and Z, we can be opponents in court and give our best for our clients. But if we walk out of there, we don't need to be enemies.
And it's strange how birds of a feather flock together. And wherever you go in social events, you always see the legal practitioners tend to flock together, whether it's a wedding or something, and they always start talking together. And they actually do gravitate towards each other.
Familiarity, or knowing each other. But it is so. There are lots and lots of lovely people in this practice, in this profession.
There are a few exceptions that make it.
There are a few exceptions, and You know, if you were going to be aggressive, at the end of the day, you're just going to make yourself unpopular. You know, people, it's much easier to go up to a colleague and say, well, can we talk about this matter? And they know that they could do the same with you. Then being bombastic and aggressive. You know, it comes, in my view, you know, it doesn't bring you far.
No, I agree with you. And also it makes me think now of the old saying, you know, it's bearing grudges, or, you know, holding grudges, and hatred, you know, fostering that hatred towards others, is like drinking a bottle of poison yourself and hoping somebody, the person you feel the hatred towards is going to die from it.
Yes, true.
So,
no, and you know what?
That doesn't happen.
and you know, matters go on. Matters reach a finality, and you've got more than one client, and you might, you know, come into contact with that colleague again, and lots of times, if you're working in a certain area, you have the same colleagues that you rub shoulders with. It's to me, it's just it's not unnecessary to be aggressive and bombastic. But that's just you know how I feel.
I agree with you. Thank you very much for your time.
Oh, it was a pleasure.
And I'm looking forward to your visit.
Yes.
To the deeds office.
Yes, I know.